A lawyer's duty to protect confidential client information is essential for client trust and effective representation. Business and Professions Code Section 6068, Subdivision E, and Rule of Professional Conduct 1.6 provide the ethical requirements for protecting this information, which cannot be revealed unless the client gives informed consent or disclosure is authorized by an exception. The duty of confidentiality is broad, covering information the client wishes to keep secret, as well as information that is embarrassing or detrimental to the client. All information learned during representation is confidential, regardless of its source, including information obtained from third parties, investigations, or public sources. There are two exceptions where a lawyer may reveal confidential information. First, a lawyer may reveal confidential client information to the extent reasonably necessary to prevent a criminal act likely to result in death or substantial bodily harm. Before doing so, the lawyer shall, if reasonable under the circumstances, attempt to persuade the client not to commit the act and inform the client of the potential disclosure. The second exception allows for disclosure during state bar compliance reviews or audits under the Client Trust Account Protection Program. This does not waive or change the confidential nature of the information. The duty of confidentiality applies to prospective and former clients and survives the end of the lawyer-client relationship. Lawyers must take reasonable steps to prevent unintentional disclosure. When this duty conflicts with other ethical obligations, lawyers must consider whether they must withdraw from representation. Violating this important duty can lead to malpractice liability and state bar discipline. Upholding confidentiality is fundamental to legal practice and reinforces public confidence in the profession.